6:38 Nashville's Morning News on Super Talk 99.7 WTN. Welcome on in. It is Monday. It is July 10th. Hope you're doing well. Dan here along with Johnny B., Ken Weaver, and Jack Johnson. State Senator and Majority Leader Jack Johnson joining us on the Newsmaker Hotline. Senator Johnson, thank you very much for joining us. And big victory for Republicans, conservatives here in the state of Tennessee. Over the weekend, turns out now we have a judge that has said that, yes, we can continue on with our ban on gender-affirming care. Of course, as you know, sir, you were very vocal, and others very vocal about how disappointed you were back. I think it was a week and a half ago when a judge issued that temporary injunction blocking portions of the law from taking effect. But again, over the weekend, a judge says that the law as written is constitutionally sound and can move forward. Now, you and I have spoken many times about this. You knew this was constitutionally sound, but this has to be a relief, at least for now.
It is, Dan. Good morning. Always good to be with you. And more importantly, I think it's good for the children of Tennessee because no longer will they be subjected to these barbaric mutilations of their bodies, either through surgery or medicine, because that's essentially what the legislation did. I am so proud of our Attorney General who not only went to battle in defense of this legislation and made sure that it would, in fact, go into effect. And I know you're going to have him on later in your show, and so proud of Attorney General Skrmetti and his staff and the hard work that they did. You know, we worked very closely with them, Dan, in crafting this legislation. We knew it would be controversial. We knew it would be subject to litigation, and they would be the ones to be defending it for us in court, and they've done an outstanding job of doing that.
Now, the lawsuit was brought by the ACLU and a Nashville family and their 15-year-old daughter. Senator Johnson, I'm just curious, have they reached out to you during this whole process, or is it at just this point the lawyers that are battling it out?
Yeah, once we pass the legislation, Dan, it's pretty much in the hands of the courts. If someone does change it, and it's a very bizarre decision that was issued by the federal district judge, Eli Richardson. If you think of this bill, think of it like a four-legged stool. Because in Tennessee and other states, unfortunately, we had medical professionals that were performing surgeries on children and then also prescribing them medications that would permanently alter the development of their body. And so in both of those situations, the legislation that I sponsored along with House Majority Leader William Lambert, on both of those instances for surgical procedures and medicinal prescribing medicine, we created a criminal penalty, and we also created a civil cause of action. So we made it a crime for doctors to perform the surgeries or to prescribe the medication. And then we also created a civil cause of action for the minor that they could take legal action civilly against the medical professional for up to 30 years past their 18th birthday. The only thing Eli Richardson enjoined in his temporary stay was the criminal penalty on the prescribing of the drugs. He left the civil remedy in place, but now even the criminal penalty will be in place as a result of what the Sixth Circuit did, and I'm very excited about that.
One of the aspects of this law is that no new procedures can be scheduled. That makes sense. And those kids currently getting gender-affirming care have to end that care within 9 months. So does that mean they can finish up their treatments, or they have to simply stop and, I don't know, I guess perhaps go to another state?
Well, that could be a possibility, but you're right. We didn't, and we were advised by medical professionals in this area who were supportive of our legislation. We didn't want to create a situation where there was an abrupt end to utilizing some of these medications, because that could be detrimental. So we were advised, and that makes sense. There are medications or things that you're on that you should not stop immediately without a tapering off period, if you will. So we put that in. Now, we recognize that for some, they may attain their 18th birthday by within that 9-month period, in which case they're free to do what they want because they're recognized as an adult in Tennessee. Right. But for your 12 and 13-year-old and 14-year-olds that were taking these horrific medications that would permanently alter their body, they need to get off of these. And so it gives them time to do that.
So, yeah, I think I would assume the entire WTN audience knows that this banning of gender affirming care is for kids under the age of 18. After 18, whatever you want to do is up to you. But let me ask you this question. This seems to be going back and forth, and even Jonathan Skrmetti, the AG, says, and he'll be with us at 7:35, that this is a great relief for now. But, I mean, the legal battle, I'm assuming, continues. I mean, what's next, and how far up do you think this will go?
Yeah, great point, Dan, and that is important for your audience to understand. What we were dealing with here, what the Sixth Circuit dealt with, was just a temporary stay of one portion of the law. There is still pending litigation that will ultimately go to trial. When you have a legal matter like this, it is often the case where the plaintiffs will file action in the court, sue based on their allegation that the law we passed is unconstitutional. Now, that trial might take months or even years before it can come to fruition. The legal system is very slow sometimes. So what they do is they ask the judges, because we think that we're going to ultimately win, will you temporarily enjoin or stay this law, not allow this law to go into effect, pending the ultimate trial? And so what Judge Richardson said at the district court level said, he said, I believe that there is a reasonable, speculation or reasonable to think that the plaintiffs will prevail in this case, and therefore I'm going to enjoin or stay this one little piece. What the Sixth Circuit said is just the opposite. They came back, and I encourage your listeners to read the opinion. It's very well written. Chief Judge Sutton from the Sixth Circuit said, no, I think that the plaintiffs will fail, or that the state will prevail in this, and this law will be determined to be constitutional, and therefore I'm overturning the stay of the lower court. I very much believe, Dan, this is a case that could end up before the Supreme Court. If it does, I hope I'm able to be there in the Supreme Court when it is argued.
Well, yeah, of course, you're co-sponsor of the bill. That would be huge. And I do predict this probably will go that high. 6:45. Senator, I'm just going to tell you, I feel like this special session has been, talked to death. I think we all understand what is going on with this special session. But I guess in other news, Bill Lee, it's been the governor, of course, calling for the special session. Effectively, red flag laws is what he is calling for. You, of course, at the center of all this controversy. Some lawmakers have been asking for the governor to actually cancel the special session. There were three House lawmakers, Brian Ritchie, Todd Warner, Janice Bowling, have all called this whole thing political theater. What is the feeling on the Senate side of the Capitol going in? We have, what the governor wants. I believe it is abundantly clear what the Republicans want. We also have a very strong suspicion and evidence that there will be some disruptors dealing with this as well, the day of the special session, August 21st. So, just give me your 45 seconds of what you think is next in this whole situation. Sure.
Well, first of all, I do believe that the governor will call us in on August 21st for a special session. He has made it very clear that he intends to do so. I am also absolutely confident, virtually 100% confident, that we are not going to pass any type of a red flag law, ERPO, extreme risk protection order. The way I characterize it in my conversations with people, we are not going to pass any type of legislation that results in someone being dispossessed from their firearms, their liberty, their Second Amendment rights when they have not committed a crime. And there's already processes in place for when they do commit a crime. So those are two things I'm very confident of, and they do conflict with one another, because one might ascertain that the governor wishes to call us in so that we will pass an order of protection bill, but he can call us in. There's one person on the face of this earth who can make us go into session, and that is the governor of the state of Tennessee. And he's my friend, but we do disagree on this particular matter. So he can call us in, but we will not be passing any type of order of protection legislation. We can, however, potentially look at other matters relative to public safety, and there are a lot of conversations about that. But one thing about special sessions, Dan, and you've covered a number of them in your time in Tennessee, typically whatever is going to be accomplished during the special session is determined well in advance. And we know the votes are there. We know the language of whatever legislation to be considered has been circulated. And we go in. The special session itself is largely a formality. It's just because we have to be there in order to pass law. So we are nowhere near that point right now. There are a lot of conversations about maybe passing this relative to mental health, or this relative to stiffening penalties on those who commit crimes with guns. There's broad agreement that we're not going to pass a red flag law. So I don't know what we end up doing during the special session, but I am confident that we will have one.
There has been a complaint filed against you by an anonymous voter in Tennessee claiming, Williamson County, that you coordinated with some political action committees, which, of course, is a violation. They also claim, Senator Johnson, that these very same PACs were connected and that those connections were never disclosed, also a violation. Now, I do believe it's worth noting that this person is anonymous, but I guess the question is, how do you respond to those allegations, that complaint? Do you have a comment?
Sure. I had a number of people who supported me, or a number of entities, political action committees and other candidates, other elected officials who supported my candidacy back last year, and I'm very grateful for their support. The law is very clear. When you have a campaign and others wish to spend money on behalf of your candidacy, either for you or against you, there can be no coordination, and there absolutely was no coordination between my campaign or any of those other entities that supported me. There were also entities out there that were opposing me, that were spending money. We adhered to all necessary campaign laws and will continue to do so. So the complaint is frivolous, but we will take the necessary steps to refute it.
All right. State Senator Jack Johnson, thank you very much for joining us here on Nashville's Morning News on Super Talk 99.7 WTN. 6:51.